Mr. Deputy Speaker,
Order. The clerk will now proceed to read the orders of the day.
Item 1, Mental Capacity Amendment Bill, second reading.
Minister for Social and Family Development.
Mr. Deputy Speaker, on behalf of the Minister for Social and Family Development, I beg to move that the bill be now read a second time. Sir, the Mental Capacity Act, or MCA, has been enacted for more than 10 years now. The MCA allows for lasting powers of attorney, or LPAs, to be registered with the public guardian. The LPA is a legal instrument through which a person, called a donor, appoints one or more persons, called donees, to make decisions on the donor's personal welfare and or property and affairs, should the donor lose mental capacity in the future to make such decisions. The MCA also allows the court to appoint a person, called deputy, to make certain decisions on behalf of a person who lacks mental capacity but has not made an LPA. The key difference between a donee and a deputy is that a donee is appointed by the donor when he or she has mental capacity, while a deputy is appointed by the court after the person has lost mental capacity. The pandemic has shown that life can be unpredictable. We never know when events that could result in the loss of mental capacity, such as accidents and diseases, may strike. Making our LPAs early offers peace of mind for ourselves and our family. For example, Mr. Loh Kim Ling, a 69-year-old retiree, and his wife made their LPAs after witnessing how the LPA ensured that the affairs of their relatives with dementia were well taken care of. Mr. Francis Ng, a 60-year-old semi-retiree, also attested to the importance of making an LPA early, as this would help his family avoid the stress and costs of applying to the court for a deputyship order. He shared that because his father had not made an LPA before losing mental capacity, he was unable to manage his father's HDB property on his behalf. Instead, he had to apply to the court to be appointed as a deputy, and reflected that the process was very stressful as it was long and tedious, in addition to having to care for his father. Unfortunately, his father passed away before the deputyship application was granted. Now, he urges his peers to make their LPAs as soon as possible. Many Singaporeans appreciate the importance of pre-planning. Already, we have more than 120,000 LPAs registered as of May 2021. This is a good sign. To encourage more Singaporeans to sign up and pre-plan, we have waived the $75 fee for LPA Form 1 applications by Singapore citizens until March 2023. This means Singaporeans need not pay any application fee when making the LPAs during this period. They will need to pay for the LPA certification service, which is about $50 or less, based on rates charged by those found on the list of the top 10 most visited doctors who are serving as certificate issuers as at January this year. LPA Form 1 is the standard LPA form used by 98% of donors to confer on their donees the power to make decisions on the personal welfare and or property and affairs of the donor. The remaining 2% use LPA Form 2, which require lawyers to draw up the specific and customized powers to be granted by the donor. In preparing for this bill, we have sought feedback from the legal and medical sectors as well as members of the public. They have provided valuable insights and they are supportive of the amendments that we are making. Let me draw the attention of this House to two key amendments proposed within the bill. Firstly, the bill will make it possible to create and execute LPA instruments electronically. Clause 3 of the bill introduces a new Part 3 Part 3A on matters pertaining to the establishment and operations of a new electronic transaction system, OPG Online or OPGO. New subsections 5 to 14 of Section 11, which are inserted by Clause 4 of the bill, will allow us to recognize an electronic copy of an LPA registered prior to the launch of OPGO to be free from error and to be treated as the lasting power of attorney if certain conditions are met. Other transactions, such as the filing of a deputy report with the Office of the Public Guardian, will be lodged via OPGO as well. This is in line with the government's commitment to harness technology to better serve Singaporeans and so that all donors and donees can reap the benefits of going digital. We will support those who are less tech-savvy so that the gains will be enjoyed by everyone. Secondly, to better protect donors against the risk of fraud, a new Section 31A inserted by Clause 12 of the bill provides that if the public guardian has reason to suspect that fraud or undue pressure has been used to induce a donor to execute an LPA or appoint a particular person as his or her donee, the public guardian may disclose to the donor: 1. The number of LPAs which have appointed the person as donee, and 2. The number of applications that are pending before the public guardian for the registration of an instrument which appoints the person as donee. LPAs today are made and executed in hard copy. To this end, we can do better. For example, Dr. Sin Yong, a certificate issuer who certifies that a donor has mental capacity to make an LPA, shared that doing away with hard copies could reduce the hassle of passing around paper forms. Indeed, by enabling LPAs to be made online, there will be greater convenience, efficiency, and security for our citizens. Let me illustrate. First, donees will be able to accept their appointments more conveniently. Donees will not need to append their wet ink signatures before a witness or to affix physical seals on the LPAs. Instead, donees will be notified of the donor's intention to appoint them via SMS and email. They can then log on to OPGO via SingPass to accept the appointment. This is especially beneficial if donees are overseas and are unable to return to Singapore to do so. We will also legally recognize electronically signed LPAs as deeds. Currently, hard copy LPAs must have wet ink signatures appended and seals affixed by the donors to be executed as deeds. Going forward, the donor will sign the LPA using his national digital identity in OPGO in the presence of a certificate issuer instead of appending wet ink signatures and affixing seals. Certificate issuers can be accredited medical practitioners, practicing lawyers, and registered psychiatrists. The new Section 12A of the Act, inserted by Clause 6 of the bill, sets out the requirements for the LPA to be executed electronically as a deed. Second, digitalization will cut the time taken to complete and register an LPA. With built-in systems checks and validations, most online LPA applications can be immediately processed upon submission. This is a substantial time saving compared to the current 3 weeks processing time. A handful of cases may require manual processing, and that will take about 8 working days. To be clear, there will still be a 3-week waiting period, allowing for any objection to the registration of the LPA to be raised. This 3-week window starts from the date the public guardian notifies the donee or donees of the acceptance of the donor's application to register the LPA. If there are no objections at the end of this 3-week waiting period, the public guardian will register the LPA instrument. On a related note, we will also tap on SingPass to retrieve personal information via MyInfo. This auto-populates the donor's particulars into the online LPA, thus increasing the ease of making an LPA. Third, robust measures ensure that LPA is properly made by the donor and not by an impersonator. In this regard, we have retained the critical requirement for the donor to execute the LPA before a certificate issuer. Under paragraph 21E of the first schedule to the Act, The certificate issuer will need to certify that the donor understands the purpose of the LPA and the scope of the authority conferred under it, and the donor is not under undue pressure or duress to make the LPA, and that there's nothing else that will prevent the LPA from being created. The certificate issuer must be satisfied that these conditions are fulfilled before the certificate issuer may certify the LPA. Both the donor and the certificate issuer will sign using a secure electronic signature, which is enabled by the National Digital Identity, before submitting it online for processing. Electronic LPAs that are easily retrievable will also reduce the risk of damaging or misplacing hard copy LPAs. Finally, OPGO will serve as a one-stop electronic transaction system for all transactions with the Office of the Public Guardian. Donors and donees will be able to easily access the registered LPA in OPGO. When transacting with third parties on behalf of a donor, donees may request for the Office of the Public Guardian to send an electronic copy of the LPA to the third party. This assures third parties that the LPA is indeed the true and latest version. Additionally, individuals will be able to conduct online LPA searches and, subject to approval, request for certified true copies of the registered LPAs via OPGO. Filing deputyship reports will also be made easier via OPGO. For example, deputies can use an online finance tracker to manage the incapacitated person's income and expenses. Certain fields in the reports will also be pre-filled with information from court documents, the previous year's report, and the finance tracker. Deputies will not have to manually complete their reports or compile their supporting documents. Instead, they can focus on caring for their incapacitated loved ones. We want all donors and donees to benefit from digitalization, and this includes those who have registered their LPAs before the launch of OPGO. The Office of the Public Guardian will make available electronic copies of all existing LPAs on OPGO. The risk of error in transferring these existing LPAs onto OPGO is low, as there is needed extraction nor entry of new data. Nevertheless, we will send a notice to all existing donors and donees via registered post, requiring them to verify the accuracy of the electronic copy on OPGO against their registered LPA. Under the new Section 11.7, they will be given 90 days after the date of notice to notify the Public Guardian of any error. If the donor has lost mental capacity, any donee may notify the Public Guardian on his or her behalf. Under the new Section 11.12, if the Public Guardian is not notified of an error, the electronic copy will be treated as the LPA after the end of the 90-day period. And if there's a notification of error within the 90-day period, the electronic copy will be treated as the LPA on the 91st day or the day on which the Public Guardian rectifies the error, whichever is later. This is to allow donors and donees to fully benefit from having the entire 90-day period to notify the Public Guardian of any error. I would like to assure members that errors discovered after the 90-day period can still be rectified by the Public Guardian. This is provided for under the new Section 15A of the Act, which is inserted by Clause 9 of the bill. Nevertheless, I strongly encourage all donees and donors to make the necessary verifications within the 90-day period. Under paragraphs 7.4, 17, 18, 19, and 20 of the amended first schedule, substituted by Clause 17 of the bill, the Public Guardian is required to attach a note to an LPA on the occurrence of certain events. Such events include the bankruptcy of the donee, which terminates the donee's authority in relation to property and affairs, and the donee's loss of mental capacity, which terminates the donee's appointment. All such notes will be attached to the electronic copy of the LPA in OPGO. As such, the electronic copy of the LPA in OPGO will be the most up-to-date copy. Third parties transacting with donees should ask for the electronic copy when verifying the donee's authority. the Office of the Public Guardian will send the electronic copy to the third party through OPGO and upon the donee's request. In the unlikely event that there's an error in the electronic copy, the new Section 16A of the Act, which is inserted by Clause 10 of the bill, protects the donee if she or he had relied on the electronic copy without knowing of the error, and protects any third party if the third party had transacted in good faith and without knowledge of the error. Let me now turn to an amendment that aims to enhance the protection of donors. There had been concerns about the exploitative behavior of donees in past discussions of the MCA. Such cases form a very small minority, and we had amended the MCA in 2016 to put in place preemptive actions. For example, the court may, under the existing Section 36A3 of the Act, suspend the donee or deputy's powers if he or she has engaged in conduct affecting his or her suitability to be a donee or deputy, and there's a risk of dissipation of the incapacitated person's assets. But we can do more to protect the donors proactively, even before an LPA is registered. There may be rare instances where a person attempts to unduly influence many donors to appoint him or her as their donee. The donee may stand to gain if any or all of the donors lose their capacity. Some donees may also fail to disclose their multiple appointments to donors, who might take that into consideration. To safeguard against such risks, the new Section 31A of the Act, which is inserted by Clause 12 of the bill, allows the public guardian to interview the donor and disclose certain information if she suspects that fraud or undue pressure has been used to induce the donor to make an LPA or appoint a person to be his or her donee. Only the number of LPAs for which the prospective donee has already been appointed or intends to be appointed may be disclosed. No other confidential information, such as the names of the other donors, will be given. However, this alone should suffice for the donor to pause and reconsider the choice of his or her donee. Further, if the public guardian has reason to suspect that fraud or undue pressure has indeed taken place, she may exercise her supervisory and investigative functions, for instance, by applying to the court under the existing Section 17 of the Act to determine if the LPA should still be registered. This amendment will not apply retrospectively to LPAs registered prior to the amendment. I'm mindful that some of us may be less comfortable navigating online services. MSF will provide support and work with our community partners to ensure that assistance is readily available. Today, almost 90% of the donees are the donor's immediate family members, of which more than 60% are below 50 years old. This is promising, as it indicates that family support is strong, with many donees often helping their older relatives fill up the hard copy LPAs. As we roll out OPGO later this year, I'm confident that many Singaporeans will continue to rely on their family to assist with the LPA applications online. To facilitate this, we have designed OPGO to leverage the multi-user SMS two-factor authentication or 2FA service provided by SingPass. Elderly users who do not know how to log on to OPGO via SingPass may opt for the SMS one-time PIN or OTP to be sent to the child's mobile phone number. The child would then be able to help the elderly log on to OPGO via SingPass. We will make OPGO as user-friendly as possible. Videos and resource guides will be incorporated into the system to guide users in the completion of the LPAs online. This includes text-to-speech functions for the visually impaired. The online guides, videos, and instructions will also be made available in vernacular languages. Members of the public who need help may also set up an appointment for one-on-one consultation at the Office of the Public Guardian. We will work closely with our partners to ensure that help is accessible at various community touchpoints. Individuals may approach the nearest Citizen Connect Centre, located at selected community centres, or the Public Service Centre, PSC, at our Tampines hub. We also welcome other community partners to work with us to bring more on board as we begin this digitalization journey. Electronic submissions of LPA applications will be the norm to ensure that the public reaps the full benefits of digitalization. But there may be exceptional circumstances that warrant the use of a hard copy form, which are specified in the new section 10C2 of the Act, inserted by Clause 3 of the Bill. For example, where personal circumstances or physical disability of the donor and/or donee results in their inability to make or sign the instrument using OPGO. Other instances include cases where the donor or donee is ineligible for a SingPass account if he or she is not a Singapore citizen, permanent resident, or long-term resident. We will also allow hard copy submissions if there's a severe and prolonged system outage. Sir, the pandemic has highlighted the importance of pre-planning for exigencies. This includes the very real risk that we may one day lose our mental capacity. It is wise to pre-plan and have peace of mind knowing that we have entrusted our well-being to a person who will act in our best interests should the need arise. Making our LPAs early will also make the caregiving journey less stressful for our loved ones who will be spared the stressful and costlier process of obtaining a court order to be appointed as a deputy. We will work this journey with our citizens to ensure that everyone can take advantage of OPGO, and it is my hope that Singaporeans will leverage this digital transformation to make their LPAs safely, conveniently, and expediently. Mr. Deputy Speaker, sir, I beg to move.